Jeff Holman. Welcome to the podcast. You're the founder of Intellectual Strategies, a company that's changing the way startups and scaling businesses access legal support. You the creator of the first fractional legal team at Intellectual Strategies, wherein companies can tap into expert legal advice at key points in their growth journey without needing the full-time in-house team or legal team that most other companies would tend to go with. You are a bit of a multifaceted entrepreneur because you've got the degrees, I believe, in electrical engineering, law, and an MBA as well. And I'm curious because having a fractional legal team is an interesting space to play in. Most companies, at least when I speak to them, don't necessarily think of the legal side of things with their business. I'd be keen to get your perspective on things. I'm curious though, why start a fractional legal service when, traditionally speaking, most companies have always asked to be on retainer or some other traditional form of engagement with companies on an ongoing basis?
Yeah, that's a great question. Thanks for having me here to chat about this. I really do think it's important that we talk with founders and businesses about these things because it doesn't take a stretch for us to look at what the industry does right now. The legal industry pretty much just says, hey, we don't really want you to talk to us. We want you to pay us a lot of money, but we're going to make it hard for you to actually get on the phone with us, or we're going to disincentivize you from calling us because, the amount of money that we charge you for phone calls. And I looked at that. I'd been in my own practice. I had been in-house, meaning I was a legal counsel inside of a company, an employee in a company. And looking back at those two experiences, they're totally different, right? When you run your own practice and you do it the way attorneys do it, you don't think as much about what the business really needs. And so when I went in-house, I realized we were doing it the wrong way. We were making it harder for people to work with us. And let's face it, so many people don't want to hire an attorney to begin with, right? They don't. And it's not that we're bad people, not all of us at least. There are a lot of great attorneys out there, and they've got a lot of great information that business owners really need. I look at it with, this might be a bit of a stretch now. I look at what's going on in the United States here with the politics, and I think what's going on with the president issuing these executive orders that are calling out these large law firms, one of the things that they're demanding, and this is really looking between the lines, like reading between the lines here, they're demanding that in these settlement agreements, whether you agree with this or not, right? There are different views on this. They're demanding that these large law firms that bill $2,000 an hour or whatever give away $10 million in pro bono services over the course of the president's remaining term or whatever. And I think there's a lot of political things going on there, but I think what is being said, just not very well, is we need to give better access to people who need access to legal services. And who needs more access to legal services than 90% of the businesses out there that are all small businesses and can't afford legal services? So this, in my mind, really comes down to what we call in the legal industry access to justice. Can the people who need to benefit from legal services, the knowledge that we've gained watching so many people screw up and fix screw ups, can the people who need that knowledge get access to it when they need it at the price they need it? That's really all this is about for me. It's how do we get that out there, and a fractional legal team, or whatever you might want to call it, getting that access to justice is super important.
Was there a pivotal moment in your journey that was the linchpin, so to speak, for Intellectual Strategies as we know it today?
There were a couple pivotal moments. One was when I decided to be less of my background is in patents, and I decided to be less of an exclusive patent attorney. It's a very good but narrow niche in the law. And I was watching my clients do fun stuff with licensing their technology or building businesses or bringing on investors. And I wanted to be a part of that. So that was the first step. Second step is when I went in-house and I said, somebody hired me to be their in-house IP attorney. And I went in-house, and 2 weeks later I said, I've been doing this wrong. I've been practicing the way attorneys taught me, not the way that the executive team needs me to practice. And then when I transitioned out of that role, I won't even say it was totally intentional, but I fell into what we would call a fractional general counsel role, where I was essentially transitioned from W-2 to a contracted position and kept doing the same stuff that I'd been doing in-house, only I was doing it fractionally for that team. Those were the things that led up to the final point, which was I watched and I experienced going through the role of fractional general counsel. What you do is you go and find some clients and you get an opportunity to work with good companies, and you're there because they need somebody who's scalable. The consequence of that is when they scale, you now are the roadblock or the bottleneck for multiple different companies who have just scaled perhaps beyond the need of one attorney. And it leads to burnout, which is precisely what all of us attorneys are trying to avoid in the first place. And it leads to frustration. And so as I looked at that and I saw the people going through that, I thought, why are we doing this on our own? Companies don't need one attorney, and they don't need one attorney with one set of skills. They need different attorneys. They need different sets of skills. And why wouldn't we do this model a little bit bigger, right? And bring a few more attorneys in so that we relieve the bottleneck pressures and we avoid the frustrations and we give them the service that the breadth of service that they really need anyways. So it was an evolution. It wasn't a spark of genius by any means, but it was certainly just some realizations trying to listen to my audience saying, how is this going? What do you need? How can we do it better? That's the quintessential question that all innovators that I've worked with, because my practice has been so much focused on innovation and creating and bringing new things to market, that I think naturally I ask that same question of myself. Isn't there a better way?
Right. It's been something of a journey for you, but I'm curious, what would you say would be your personal area of strength?
So I do have a very solid background in technology because of my electrical engineering background. A dozen, 15 years, something, doing patents, working with technology companies across companies like IBM, Intel, Apple, down to garage startups. I've seen a lot of that. I've done a lot of different technologies. So that's like from a legal standpoint, I'm very good at that. From a business standpoint, though, which I think is more important for a lot of our clients, they really need somebody who can speak legal terms to them in non-legal terms. How do you translate the engineering and the business and the legal into everyday leadership conversation? Because that's really what it comes down to. If we're doing our jobs right as in-house or fractional legal counsel, then what we're doing is we're helping the business move forward faster. And so translating everything into actionable advice is really the best skill that I think any attorney can bring to the table. And with an engineering, business, and law background, I got my MBA last out of those 3 degrees. And while I learned a lot of things, I made a lot of friends, grew some networks, I do like legitimately look at that and say, I think that the best thing I got out of my MBA was vocabulary, so that I can now speak the language. I can bring my legal expertise and my engineering technology expertise to the table, but I can speak the language of business with the teams that I work with. So translator is the word I would use for my skill.
And in that area of strength, this area being a translator, would you say is something that businesses don't know, but should?
Oh, can I narrow that
Sure.
down a little bit? I love to talk about businesses in terms of first-time founders and second-time founders. If we're talking about first-time founders, the answer is pretty much everything. First-time founders, and I love first-time founders because they're so eager to build something, create something new, bring something out of their mind into the hands of their consumers. And it's a beautiful thing. But there are so many hidden monsters and traps around the corners that they just don't know about, and they think that's not going to happen to me. I liken it to if you have children. When you have your first child, you say to yourself, I never would have guessed this is what it was like. I think I knew what it was, but I didn't really even know what it was. Now that I have a child, I'm holding a child in my arms. I brought them home. They actually let me bring this little human home from the hospital without supervision. That doesn't seem right. It's a totally different experience, and you don't know it until you've been through it. And first-time founders are that same way. They're bringing a baby home, but they don't know all the things that they don't know until they've experienced them. And so if we're talking about first-time founders, you really need to surround yourself with experienced people, whether that's paid legal advisors or unpaid business advisors, mentors, coaches, whoever it might be. You need experienced people, but you definitely need somebody to tell you about the legal issues that you're going to run into. You need somebody to tell you about the financial issues that you need to be aware of. And then you just need smart people who you can go and bounce ideas off of. Those are the three that I would say everyone needs. And that need is going to change as people go through business, as they become second and third time founders, or if they're in different roles in the company. But first time founders really need to know that there's too much that they don't know, and they need someone to help them navigate that.
Certainly. You say it would be a little bit different for a second, third time founders. Could you elaborate on that?
Yeah, I think the other thing, what I would say for second and third time founders, and they're better at this, but it's still difficult. I work with a lot of startups and scale ups and fast paced teams. And so when you're in that world, you're trying to make things happen. Sales are down, you're trying to get sales up, whatever. There's a tendency to misdocumenting things, right? You don't document the things that need to be documented. And that may sound like a silly thing, but again, translating the legal into the non-legal and the business language, it's writing those things down. If I could give one piece of advice, it would be write down the decisions that you're making with the people you're making them with, and make sure that when you write them down, everyone agrees that it reflects their expectations. Because we deal with a lot of cool things happening in companies, but we also have to clean up some things that aren't so fun. Disputes among founders and investors and just things that go sideways, I'll call it. And it's usually because one party just simply expected something different than the other party is expecting. And if they would have just written it down, there probably would have been an opportunity to discover that misalignment in expectations earlier on and address it at the beginning. Because I talk to a lot of founders who are starting businesses, and I always tell them, listen, let's just get everything out in the open now, because right now, everyone's going to say yes to pretty much everything. Nobody has problems with whether or not they're going to have to vest, or how you deal with a partner who stops communicating with you, perhaps, or things like that. But once they become issues, they're issues because people don't want to talk about them. And if you haven't talked about it and people then don't want to talk about it or don't even want to talk to each other, how do you resolve it at that point? So let me take my suggestion of writing things down one step further. In law, a lot of times you hear about people doing agreements, but before they do an agreement, they might do something called a term sheet or a letter of intent, right? A memorandum of understanding, whatever you want to call these things. I'm a huge advocate for that. I think that unless it's going to delay the project unnecessarily, and that's the reason a lot of founders will decline to use these. They're like, oh, I can't slow down this sale. I got to get the money in the door, or this investor needs to put his money in. I can't slow it down. So I get that's a very common excuse that they're already using. But I think that using some type of preliminary term sheet would be a huge time saver in the end for people for very little effort up front. It's an easy, quick, and can be pretty thorough way to document these important expectations up front.
Very interesting. And I'm also curious, do you at times have conversations with CFOs where there is a need to quantify the ROI of a fractional legal team in terms of things such as revenue protection or cost avoidance metrics? And I wonder if you could share an example to frame that conversation.
Yeah, I'll admit this is an area that's really tough for legal to manage, because a lot of what we're doing is preventing issues from happening that would cost the company money. And so I might have to think for just a second about a good example of a conversation I've actually had. Let me tell you in the meantime, just a quick anecdote that comes to mind. I had a client who they were doing some online advertising about something. They're brazen a little bit in some of the things they say and some of the ways they advertise. And I was sitting at home just one evening. I was on Facebook scrolling on my phone, and all of a sudden an ad popped up, and I'm like, oh, That's probably not a good ad to do because it involves a celebrity. I haven't seen anything come through about authorizations from that celebrity, and that's a celebrity who very well could say, "You guys now owe me $1 million, right? You've used me and violated my rights of publicity or whatever." And I just jump on the phone, or I think I might have sent a text at that point and said, "Hey team, by the way, I noticed this ad is running. Have you guys gotten approvals to use this celebrity's image and information? If not, let me save you $1 million." I think I said something actually like that. I'm like, "Let me save you $1 million and let's take that down until we can talk." And so they ended up taking the ad down until we talked. It wasn't necessarily a direct conversation with the CFO, although I believe he was probably on that text. But it wasn't a direct ROI calculation. But literally it was, this could be $1 million issue very easily if you don't resolve it quickly. And don't hesitate to throw those numbers out there, because it is difficult to sit down with an Excel spreadsheet and be like, this is the return that you're getting on investing in our team or in other legal services. I've seen other teams that go to more extent, and they will document not just every 6 minutes of time that they do, but they'll document how fast they turn around deals. Because the sales team, that's important to them. Sales is notorious for coming to us. They've had an agreement in hand for 2 weeks, and they come to us and they say, "Hey, it's end of quarter. I need this done by the end of today, but don't worry, it's really easy." And we're like, "No, that's not how it works. But you've had it for 2 weeks. We actually have to look at it, and there's some jarring term in there that could cause a lot of damage to the company, but they want it turned around in a day." So there are teams who are starting to use AI and use other tracking systems to say, this is the amount of work we did. This is how fast we turn things around in kind of incremental units, like from this getting a draft to turning around versus, and also from the start of the project to the end of the project. How quickly did legal turn this around relative to the time that it was maybe with the opposing party and the time it was with other members of the team, and show that in a way, we're not actually the roadblock here. If you think there are roadblocks, it's not us. So it'll be interesting. I think there's probably an opportunity actually there to maybe develop some tools or AI agents or whatnot, and come up with some more of those tracking types of metrics. But right now I can't say in good faith that we're doing a ton of that in a way that I think is great to communicate with the CFOs.
So in my mind, it would almost be, I would liken it to not quite disaster planning, but at least ensuring continuity of business as usual, despite events that might occur and disrupt your operation in some shape or form. I'm also curious about IP strategy and building moats, especially given AI, as you just mentioned, evolving very quickly. I wonder if you have an example of a client where aligning IP strategy with investor expectations during, say, a funding round helped increase their valuation. And if so, were there particular patent or trademark moves that spoke to that increase in valuation?
Yeah, I'm not sure if what I did improved the valuation or just made the due diligence process easier. I don't want to downplay. Improving valuation would be fantastic. Candidly, most investors are a little bit naive in a way about IP. Or maybe the better way to say that is, those that aren't naive don't put as much weight on IP as a lot of the other factors like team and traction and sales revenue and things like that. I don't want to pretend that a patent is necessarily going to move the needle significantly on the valuation that the investors give to the company. I will say though that the valuation can definitely be negatively impacted by the lack of IP generally. And so from an IP strategy standpoint, there are a couple ways to think about this. And I love that you mentioned alignment, right? I think that the first level of any strategy is making sure that everyone's pointed in the same direction. And a lot of times we talk about marketing strategy, or we talk about go-to-market strategy, or we talk about your investment strategy or IP strategy or legal strategy, whatever it might be. Those are nothing more, or they shouldn't be anything more than just slices of your overall business strategy. Because if you don't have a business strategy overall, or you have departments in your company that are not aligned with your overall business strategy, then somebody is not working on strategy so much as something else, right? And so IP strategy really is about aligning the IP assets with your overall business objectives, your leadership position, your sustainable competitive advantage, all of that. So that being said, what we've done for some companies is we'll go in and we will actually implement a ranking system for their patents and trademarks. And we'll say, okay, how does this patent asset align with your primary product lines or your revenue streams? How protectable is it? And we'll go through a series of, could be 4, could be 8, could be a dozen different factors for each one of their patents and trademarks, and we'll actually give them ranking scores. And it's funny, I was in a room with a bunch of engineers one time, and I was presenting this to them and saying, here's how we're going to do this. And they're like, isn't this just, I don't understand why this is so helpful. You're just creating arbitrary numbers. And I didn't say it to them at the time, but I thought to myself, yes, they're arbitrary, but they're relative to each other. We're trying to figure out what to prioritize in your business that's most aligned with your business versus those things that are less aligned. Because inevitably, working with startups especially, you patent something today and next year you pivot your business model and that thing might not be aligned anymore. And so I wanted to say to this group of engineers, I said, yes, it's very arbitrary, just like the concept of time. Somebody at some point made up the concept of hours in the day. It's just a concept. It means nothing other than the value we give to it. But I don't think anyone would disagree that time is an extremely useful, although arbitrary, type of system that's been made up for our use. IP strategy scoring is also arbitrary perhaps, but it can be extremely useful in giving insights into the portfolios about alignment. Because here's what you'll find without something like that. You'll find that the executive team, the investors, the board of directors, even the technology team within the company perhaps, they look at a set of 100 patents and it's overwhelming. They're like, I don't know exactly what's what in here. I don't know which ones are important to us. And they make decisions up front. Somebody will submit a disclosure and somebody will review it and say, yeah, we should do this one. But after that point, it takes a year and a half usually to get an office action. You get an office action back. And by that point, people don't know if that patent is really important to them anymore. And then when the patent gets issued, especially if you've got patents issued across countries, you have lots of renewal fees and deadlines on an annual basis. And so that you'll say, do you want to pay $2,000 to renew this patent in France or wherever? And they don't know how to make an informed decision. And so what they do is they default to saying yes to more stuff than they probably should, which from an ROI standpoint is probably closer to waste than it is to invested funding. So you see, in fact, I had somebody one time, a client said to me, your budget for IP this year is $0. And I said, well, that's interesting because you have 150 patents and patent applications and a bunch of trademarks. What would you like me to tell the board? Or do you want to tell the board that we'll just have to let all of those go abandoned? Because there are fees due all the time. And they were so overwhelmed that and probably in a financial crunch, that they said, we can't afford any of this anymore. And so just let it go. So officially I was working off of $0, and unofficially I'll bet we spent $700,000 or $800,000 on the IP portfolio. It just was, somebody thought it would be better to tell, I don't know, the board of directors that we weren't spending that much money on legal when in fact it was being spent. So, but that's just an illustration. I don't fault somebody necessarily for creating that cognitive dissonance, I guess, but it's probably a result of them not having the insight into their portfolio that they really needed to have at the time. And the way that it had been built up when we took it over was a little haphazard. And so we tried to part of what we did was bring the structure to that portfolio so that for the next year, they could make better decisions. In fact, they've been a client now for 10 years or so. And we've worked with them on a lot of issues about how to make good decisions based on rankings within their portfolio.
AI evolving as quickly as it has, companies, and I'm thinking perhaps primarily of software service SaaS type companies, have had a bit of a hit to their valuations, given AI is able to replicate a lot of what these platforms are able to offer. And given the rapid evolution of AI, what advice would you give to companies, especially in terms of adapting their IP strategies in this space, and especially when technologies are evolving fast, patent approvals, I'm assuming, still take quite a bit of time to come through, and what, if any, interim protections would you recommend as well?
Okay, great question. There's a couple layers there, I think. So one thing that I try to advise companies is to create layers of IP, right? Because there is, in addition to the misalignment that I've already mentioned, and that misalignment is dynamic, right? Things don't start out on day one misaligned, but on day two they might be a little misaligned. Day three they might be more misaligned, depending on just how the prosecution of the patents go and how the evolution of the company goes and the business model. And so there's this issue of misalignment, but one of the things that companies can do is that they can start to create layers of IP protection. And layers could be across different types of IP. You've got patents, you've got trademarks for your brand, you've got copyrights for your works of authorship, you've got trade secrets, and then you've got all the contractual agreements that you put into place to govern all those forms of IP. So you can get different types of IP into your layers of IP. The other thing you can do is you can create layers within a specific type of IP. I was talking with a client this morning. We were talking about what I call an incremental patent filing strategy, where part of what we specifically do for new clients who are developing a product and they want to get a level of protection in place so they can start to move forward in that development process is we will, from the beginning, plan to file a first patent application. This is often something we do with provisional patent applications. We'll file a first provisional patent application on the concept as it sits now. And then as meaningful improvements are made in the design process, we'll file incremental provisional patent applications for a fraction of the original cost, building on that original patent application. And we'll file those to create this stack of IP that can then all be folded into a non-provisional utility application going forward. You can do the same thing in the trademark world, where you take different versions of your name, your logo, your other branding assets, and you can protect those in different ways for different classes of goods and services. And all of this, of course, takes funding. And so it depends on the funding, the amount of layering that you can do. But it's certainly something that companies should be looking at from the beginning and working into their IP strategy over time as they can.
Is there a point where defensive publishing is a smarter revenue protection tactic than pursuing formal patents?
I would say the short answer to that question is probably no. And it's not because I'm a patent attorney by nature, only because the way you asked the question was whether or not defensive publishing might protect revenue. And I don't think that defensive publishing is a revenue protector in any way. It might. The only thing that's going to protect your revenue is an issued patent that you have the means to successfully enforce against other people. That's the only definitive way to protect your revenue. If you want to publish defensively, it would be so that other people don't have the opportunity to get patents for themselves, right? You publish it to keep the roadway clear for everybody. It's not just for you, it's for you and the other people that you're competing against. They would have access to that same technology, perhaps, unless somehow it's very aligned with some type of patented technology that you already own foundationally, and the new publications are building on that foundational technology. That might be an area where you are continuing to make it hard for your competitors to get their own patent protection, because if you've published it, then it's prior art for them. And even if it was a meaningful, novel, non-obvious improvement over your original invention, they wouldn't be able to get a patent and then come and picket fence you. It can be helpful. It's much more economical, obviously, but the outcome is very different than the patent process, I would say.
Certainly. As you speak to founders and CEOs of companies, and you need them to move fairly quickly, to address legal debt without really stifling their agility, especially in fast-moving markets. Is there a debt to growth ratio framework that you would use to help them understand things as they stand?
I like that you use the phrase legal debt, but just so I make sure I'm addressing the right question, maybe give me a little bit more context for what you mean by that.
So if you see potential legal issues coming up that would put them more in the debt as a side of the accounting, so to speak, is there a framework that you would use to help them see that point of view and how it could affect not just their agility, but ROI and profits as well in the medium to long term?
Yeah, perhaps we call it a framework. So we like to use some playbooks. Every company every company, regardless of size, has a lot of the same structural components as every other company. Even if it's a one-man show or a 10-person business that's growing, you still have HR issues, you still have funding issues, you still have customer issues and supplier issues and maybe investors, and you have corporate governance issues, you might have IP issues, you have branding issues. And you could say global Fortune 500 company has all those issues at a very large scale, and they have teams to deal with it, right? A 10-person startup has all those same issues. They just don't have teams. They have one or two people wearing 7 or 8 hats each to try to manage those issues. So the issues are there. And so a lot of times for startups, because of the resource constraints, there's two things. There's resource constraints. So even when you know about an issue, it's hard to prioritize that over selling your product and making money. But a lot of times the resource constraints are secondary to the fact that sometimes founders just don't know what they don't know. And this gets back to that first-time founder mentality, especially where these playbooks that we have can help people walk through and identify, okay, what are the things that we should be looking for? What are the types of words that come up in our team meetings that might be triggers for actual legal issues, right? Like e-commerce companies that we work with, they might run into product liability issues, and I can tell you right now, no founder I've ever worked with in an e-commerce company ever comes to me and the first thing they say is, tell me about product liability. They're like, I have a new product. Let's get a patent. I want to sell this in these areas. And it's all about making and selling and developing their product and creating a brand around it and getting it into retail at some point. It's not about product liability. And so that's not their focus. Whether they know about product liability or not, they're not putting their attention and time and resources to that. So the playbooks are there to help say, hey, all this other stuff is really important. Making money by all means, that's hugely important because you won't have a business and I wouldn't be here to work with you if you didn't make money. But let's put a little bit of time and attention to the issue of product liability so that you know what types of triggers to look for that might tell you that this is a growing issue in your business. That's probably the most framework type of thing that we do is these playbooks.
Okay. So I'm hearing aspects of risk mitigation in the overall thinking and process. Is scenario planning a part of that in order to, at times, perhaps even stress test clients' legal strategy against black swan events?
Oh, this is getting deep here. So stress testing, I would say in the startup world, everything is, and I don't mean to be short in my answer here, but really in the startup world that I work in, so many of these issues are stress tests. You're stressing the entire business on a daily basis because your resources are spread so thin. So candidly, I don't think that there's a lot of stress testing going on the day-to-day in these businesses, so much as survival going on. They're trying, and if we can get them to even do the legal issues that are critical, then I'm pretty happy about it most of the time because resource constraints don't allow them to do a lot of the non-critical issues. There's a lot of people who come to us with issues, and one of the approaches that we try to do at my law firm here at Intellectual Strategies is we try to give risk assessments where we say, okay, here are the factors, and we'll put a high, moderate, or low risk assessment with those factors. So it's not super detailed. Maybe it's a little bit more detailed than some other people will do, but because we don't just tell you, oh, you have to, like, here's your non-disclosure agreement, you have to do this. We're like, hey, what are the risks associated with this relationship, for example? And here are some of the common factors, and this is a pretty high risk, this is probably moderate, and these ones are low. And so we'll try to help do that assessment up front. We do that for, you want to file a patent application, we do that for patent searching, and here's a prior art that we found and the risks associated with being able to get a patent or a trademark, for example. We'll do that with other areas. So when we can get a kind of a heads up front, we love to do that. And it helps us direct the attention of the team to those high risk factors. Because again, as I said, if we can address the high risk factors, then we've covered 80% of the problem. And we've probably also exhausted the attention span of the team for legal issues for the time being.
Thank you for sharing that. I was just thinking of companies, perhaps say in the fintech space, where you've got a lot of compliance requirements. And I'm just wonder if you've been able to help some of these companies actually turn or reposition these compliance requirements into unique selling propositions that have actually helped drive revenue.
So we haven't done a ton of fintech companies specifically. That's an area where some of that financial regulatory compliance is more specialized, and we would bring somebody in our team to help out with that. We've got a couple clients though who are in the edge of those spaces, and they're creating products that they're working with banks to implement, or they're implementing what one is a marketplace that is selling private items online and restructuring how the market for that industry really works. And they're doing that in compliance with a lot of banking, what would I call it, banking tools and resources on the back end. So we are exposed to some of that tangentially, but I probably couldn't say in good faith that we're doing a lot of the strategy on the fintech side of it, because I think that's outside of what we're.
Have there been instances where clients are looking to go international or perhaps even global? And if so, I'm sure there's a lot of regulatory market conditions to tackle. I'm curious as to how you would help companies prioritize which regulatory markets to tackle first, and the process for mitigating unforeseen compliance risks as well.
Yeah, so we've had it both directions, right? We've got some clients who have expanded out of the US into other countries, established offices in Europe and Asia and places. And then we've got a lot of smaller companies who originate from outside the US and are coming into the US to sell their products and services. So we do see that both directions. I think that your question specifically, I think, was about how we help them mitigate risks associated with that international expansion. From some standpoints, a lot of it's really just about education at this level, right? It's people don't really think, they don't really think, oh, I'm going to send a product abroad one direction or the other. And there are export control laws that countries actually say that you have to comply with to export without violating that country's export control laws. So a lot of it is us seeing those triggers in the businesses and saying, have you done any export control compliance on this? Because that's an area that's not very fun. There are very few experts out there who I think are doing a very thorough, knowledgeable job at it. There are some, but they're a lot fewer than, say, the people who are writing contracts for people. Then you get into areas like transfer tax, where some of these areas, whether we're teaming up with other legal experts or we are teaming up with financial experts, these types of issues tend to create a lot of opportunities for collaboration. And so we've worked with legal teams in China to set up Chinese entities. We work with financial professionals to help get the transfer tax issues, I wouldn't say resolved, but set up correctly for businesses. And we're doing the legal memorialization or documentation of the transfer tax issues, whereas the finance team and the advisors are probably the ones who are setting up what actually needs to happen, rates and stuff like that. I'm not sure if I'm answering your question, but I think there's an area where you really companies need to be mindful of bringing in the right experts. And as good as we are, we have 5 attorneys, we're very good at a lot of things, but there are some special scenarios. And the ones you're raising right now, fintech issues, I would say HIPAA issues, and international issues, you have to start thinking Startups need to be thinking about this in terms of getting the team of experts to the table, not just relying on one person who they think should be able to do it all. It's like you've graduated from maybe general surgery where you have a surgeon that, I don't know what they do. They take an appendix out or something to a situation that is much, much more complex. And you're dealing with a team of surgeons who are now conferencing on a regular basis to make sure that the chemotherapy that they're giving you and the other modalities are all working together and not working against each other. And I picture a team of 6 doctors sitting in a room trying to figure out the right solution for a critical patient. And I think you're getting into those areas, those topics and industries where that becomes a lot more of the norm than the day-to-day local business.
Thinking from a CEO or founder's perspective needs to change from how do we resolve this to who can help us best resolve this as perhaps more of a fundamental issue. And from your point of view, I'm curious, how are you building these networks to allow for these specialized bits of knowledge and abilities to come and service your clients?
Maybe ironically a little bit, the first 10 years that I was practicing mostly just as a patent attorney, we really built up a network of foreign counsel, we call them, mostly patent IP attorneys in other countries. I bet we've worked with 40 other countries over the years. A lot of the major ones that people would also be doing business in one form or another. That's been a huge resource for us to be able to go and say, our patent attorney, we don't expect our patent attorney to be the export compliance expert in their country, but they'll know somebody, right? And we'll rely on the network we've built up over time around patents and IP to then find other experts for these other issues. And so it's also something that there are some networks out there, some legal networks. People are always building up this. I think I got an invitation to join, I don't remember if it was a European or Asian network of attorneys. And so there are some networks out there that you can join. We haven't utilized those networks specifically. I don't necessarily believe that paid networks are always the best way to find the right counsel especially for startups who are on budget constraints like we work with. So we usually have to do a little bit more one-on-one digging and connecting. And we'll do it on an ad hoc basis. As things come up, we'll reach out and we'll say, hey, this issue's coming up. And so a lot of times we'll reach out beforehand. We say, we have a client who might need this thing. Do you know somebody? And try to put a couple of people in place in case that issue really develops into something that needs to be handled. So that's how we've done it.
I'm also thinking on one level, you're speaking to the legal issues, but I would imagine there would be a fair bit of communication and input into the operations of a company. And are there situations where you're almost embedded into product development side of things as well?
Yeah, that is precisely our goal as a fractional legal team, is to be as embedded as possible throughout the company. When I first started transitioning from patent attorney, I'll say, into more of a general counsel attorney, I did a mapping one time of one company and I said, okay, here's all the issues that you're dealing with. And it was this hub and spoke type of map of the operations of the business, the different functions of the business. And my role at the time was to come in and help them manage their IP. And I said, which of these 27 different functions have IP issues related to them? And I just would color code them green as I went through it. I'm like, oh, this one does and this one does. By the time I was done, I think 24 out of the 27 were green, which was eye-opening for me because I hadn't thought of intellectual property as being that pervasive throughout a company. And that was helpful for me and part of the beginning of me really opening my eyes and saying, wait, there's a better way to do this. Because if you look at it now, like all those functions, if IP is an issue in 24 out of 27 different functions, I'm just making those numbers up because I don't remember the exact numbers. But if it's that pervasive of an issue, then legal is also just as pervasive, if not more pervasive. And so what we want to do is we want to make it as easy as possible for somebody to poke their head into our door, our virtual door, and say, hey, Jeff, I got a question. Do you have a second? And ask us those questions, because I think this is a corollary to the work from home versus in office, right? Return to office movements. And we all know that the types of collaborations and communications that happen in office are just different. And so I've actually been For some of my clients, I've said, hey, listen, I know you're not paying me that much yet, but I'm going to be in the area. I'm going to come sit in your office for half a day today, or on a regular basis, be in your office for a few hours. I'll park myself wherever you've got room, a conference table, a couch. It doesn't matter. I've got stuff I can work on if you don't need me, but I'm just going to be here and be available and in your space, because I know that if I'm there, I'm going to get 10 questions that nobody was going to call me up and ask me if I wasn't there.
Interesting.
And so I hear the chat going on. People come and they ask me, hey, since you're here, I had this quick question. And so you just being embedded is the almost the entire objective of a fractional legal team, or a fractional CFO, fractional CMO. They want to be embedded, as do we with our legal team.
We've covered a fair bit of ground, and I'm curious, in the space of using fractional services to drive revenue growth, are there perhaps a couple of areas that do not get talked about very much or tend to get glossed over? If so, what would they be?
Areas that get glossed over for revenue growth. From an IP perspective, it's really easy to look at IP and say that's a different animal, and it's hard to understand how to monetize it, right? I've had clients in the past who they've had IP assets, and they've looked at them, we've evaluated them, we've spent a lot of money evaluating them sometimes, and we say there's a possibility of going and taking this to company XYZ and demanding a license for it. And in some cases, that I think in one case in particular that I'm imagining right now, that I'm remembering, it could have been tens of millions of dollars, but the investment to get to that point, it could have. I mentioned this to somebody on a call the other day. It could have been a phone call. It could have been a demand letter or something simple that resulted in it. But it also could have been litigation, right? It could have been asserting it and suing over it, and it could have been $1 million or $2 million to try to get to that point. And so there's so much, when you're talking about using legal to drive revenue, it's a really tough subject because there's so much instability and speculation in that. In fact, I was reading a little bit a month ago or so about the what do you call it, the kind of historical development of general counsel roles in companies. And early on, general counsel, they were these esteemed advisors that advised on all sorts of business and legal issues. And then at some point, I think this account said it was like in the 50s or 60s, big law, meaning large law firms with 1,000 attorneys, or at the time, hundreds of attorneys, were collaborating with well-known law schools to redefine what general counsel roles meant. And companies at the same time were getting large enough that they started using legal strategy as part of their commercialization or revenue generation strategy. Whereas prior to that, it was more about compliance and relationships and managing those things. And then it became like IBM, they aren't necessarily aggressive about asserting their patent portfolio, but for 40 years, they were the number one patent awardee from the U.S. Patent and Trademark Office, for the sole purpose of building up an asset pool that they could then use defensively, they claimed, to drive revenue when somebody else would offensively attack them. And so it became such a driver that IBM is not the same company today that it was 30 years ago. It's much less. They've got some hardware divisions and things like that, but I think I heard at one point, this was back when I was doing more work for IBM, patent work for them, that their patent licensing was their number one revenue stream, more so than any of the other hardware or software or business intelligence businesses that they had created. I don't know if that's true or not, but that's what I'd heard. So anyway, they're historically even, it's interesting to note that legal strategy has been weaponized in a way. Maybe that's the wrong word. It's been deployed to drive revenue, and that's much easier to do on a very large scale. But even small companies can do that. That's one of the powers of IP. This is why the inventor in his garage has an idea, believes in it, develops it. People will come and they'll put money into that idea as though it's worth $2 million from day one, just because the idea exists and somebody's willing to work on it. even though there's no revenue for 4 years, they'll put money into it, they'll develop it. And a lot of times that's just around the idea, but also the team that's able to implement, able to bring that idea to market. And so I don't know, it's an interesting world. It's a lot harder to do. The success rate is pretty low, but it's high enough that enough people want to try it that we're still seeing people launch businesses around. It really comes down to new products and new brands. And if you can do that, you might be the next unicorn or what animal we're using these days.
I'd like to switch perspectives for just a little bit. I'm sure the fractional service that you offer is quite attractive to a lot of people in the startup space, the SaaS space, etc. And I'm sure compliance issues would also mean that clients would be looking for a solution. But given your journey to date, and perhaps more recently, what would you say has been the biggest driver of growth for intellectual strategies?
Oh, if we're talking drivers, the key drivers for us, it's referrals, right? People who've used our services. One of the things I've done with the business since I started it was I called it a name that I like, but it's a name that is trademarkable because it's unique. But because it's unique, it also has some challenges in educating the market about what we do. I had friends early on who'd be like, intellectual strategies, are you still practicing law? What are you doing? Because the name wasn't traditional. And so we've tried to position ourselves in a way that it does stand out a little bit from a normal law firm. We operate a little differently than a normal law firm. But in the end, and I think more and more law firms should move towards this model that we're doing. Or where I see it going is I see smaller law firms who are able to operate in this way at acceptable margins for a small law firm being partnered up with larger law firms who operate with a different model that doesn't allow them to do what we're doing. Large, big law firm that is focused on huge transactions, $1 million transactions. They don't necessarily, they accept, this is what I'm told. I'm not one of these law firms, but what I'm told is they accept all of this other small work from these companies as a tax to get to the big projects. They want the funding and they want the mergers and acquisitions and they want the large litigation and things like that. And so I think that we'll see more companies like mine embedding themselves with smaller growing clients and in a collaborative nature with big law firms that are doing the projects that are beyond this. We can't do some of those huge projects. We're not equipped for that. We don't have the team for that. And maybe we don't have the appetite for that either, because they work a different lifestyle than we work. But I could very well see in the near future more people doing what we're doing. And I could also see more collaboration among different sizes of firms that's mutually beneficial to the big firms, the small firms, and the clients. And I won't be surprised if we get there in the next 4 or 5 years.
Very interesting. Jeff, if you were listening to this episode, what would you say would be your top takeaway?
My top takeaway, maybe we'll go back to the beginning, right? It's just document stuff. If you're a small business attorney listening to this and thinking, how can I protect myself a little bit better today than I did yesterday? You can hire an attorney that can help you do it if you've got the funds to do that. But whether you do or don't hire an attorney, you should be documenting stuff better. That's going to be your best way to de-risk your business, is just a little bit of documentation.
And if listeners are curious, want to find out more or connect with you, where would you recommend they head to?
Yeah, people can connect with me on LinkedIn. I'm there quite a bit. Just look for me, Jeff Holman. It says something about building fractional legal teams on LinkedIn. That's a great place. If there are other people who are looking to maybe explore where they're headed, what risks they're looking at in their own business, I do a free 30-minute strategy call with potential clients. So people can get onto our website, which is just intellectualstrategies.com. They can see my calendar. They can book a call with me, and we'll chat about the messes you've made or the messes you need to clean up or where you're headed with your business milestones over the next 12 to 18 months and how legal fits into that. So happy to have that call. I always love connecting with innovative people.
We'll include links to that in the show notes. Jeff, thank you so much for doing this.
Yeah, thanks for having me. It's been a pleasure.